First case is Buchanan versus State.
Good morning. Thank you. I'm Briggs Thomas. May it please the court, firm of Shepard, White, Thomas, Ferguson, Jacksonville. I would like to reserve 5 minutes of my time. We are arguing today that there were 3 reversible errors committed in the trial court. One is the denial to Mr. Buchanan of 10 peremptory challenges and jury selection to which the law clearly entitled to it. The second is the denial of a special requested jury instruction that was proposed on his behalf, which is a jury instruction that is unique to the circumstances of a bail bondsman seeking to recapture a fugitive bailee. And the third issue, of which there are some specific sub-issues, is the trial court's erroneous limitation of cross-examination of the key state witness, the alleged victim in the case. With respect to the issue of peremptory challenges, under the 1020 life law, the crime charged under the amended information in this case was clearly punishable by life. That is set forth specifically in the amended information, each element that indeed there was an aggravated battery, that indeed there was a firearm involved, and indeed there was bodily injury.
Well, what do you make of the trial judge agreeing in advance that he was not sentenced to life?
That has no bearing on it, because the law, under both Florida Rules of Criminal Procedure and the statute, provides that in any circumstance where the offense is punishable by life, each side is entitled to 10 peremptory challenges.
Well, does the trial judge have a right to limit the punishment so as to limit the number of peremptory challenges?
Florida law does not allow that. There is no case, there's no statutory provision, there's no rule provision that provides that a judge can foreclose peremptory challenges by doing that, in the way that a court at times can deny the right to counsel or the right to a jury trial, depending on what the potential outcome would be.
Was the error preserved below?
Absolutely. What happened below was that the defendant argued specifically, we're entitled to 10 peremptory challenges. This is punishable by life. It was argued substantially. At the conclusion of the argument, the trial judge said, well, I think this is governed by a case that relates to habitual offender sentencing, where the case law provides that a habitual offender who can be habitualized to a life term is not entitled to the additional peremptory challenges. We've cited the law in our briefs to the effect that that is an incorrect conclusion of law on this issue as to this case. And at that point, he had ruled conclusively. The Florida Supreme Court in Bailey, which we've cited in our case, in our briefs, the Bell case from the 2nd District, which is the one that's absolutely directly on point, says that where the judge has conclusively ruled, you don't have to keep beating your head against the wall.
Any evidence in the record that a 7th peremptory would have been used so as to argue whether or not there would have been a different jury to hear this case?
No, because this was not a situation where that was required under the principles that relate to erroneous denials of challenges for cause. Where there's an erroneous denial of a challenge for cause, one has to take a further step. That is something that happens during the selection process itself, frequently even near the conclusion of the process. What happened here, though, is from the get-go, the trial judge says you only get 6. Therefore, the entirety of the jury selection strategy and thinking and the whole manner of determining who to strike peremptorily or not from the very beginning, from the first juror considered, is affected. That's why cases such as Bell hold that denial necessarily inheres in the verdict, and hold that where there is a conclusive ruling, you don't have to keep objecting every time. You don't have to make a further record.
But didn't trial counsel accept the jury after it was selected?
Trial counsel was asked this question, the record shows. After the conclusion of the bench conference at which the peremptory challenges were exercised, counsel withdrew into the body of the courtroom with the jurors present and was asked, are these the jurors who we selected? Yes. What's trial counsel supposed to do? Say no and cause a mistrial? That's merely an acknowledgement. What occurred in the record is merely an acknowledgement that indeed those people were the same people who were chosen as a result of the exercise of peremptory sidebar. That is not an affirmative acceptance that we're happy with the jury. It's a different animal. You certainly see certain cases in which there is a different record. For instance, there are the cases in which a party, and for instance, the Dante case, which is cited in the briefs, is one. It was a post-conviction case, I believe, but it's one in which there was an exercise of a peremptory, but then the defense withdrew that and said, we like this jury. They affirmatively said, this is our jury that we want. That's a different animal than simply acquiescing. It's a different animal than simply responding to a judge saying, you only get 6 peremptories, and counsel saying, okay. That's not an acquiescence to that ruling of the court. It's merely a recognition that the court's ruled, and a good lawyer not arguing with a ruling that's already made, beyond what argument has already been made.
Well, I guess the point of the question, Mr. Thomas, is that if we have situations where a challenge for cause is made and denied, and the trial counsel believes that challenge was wrongfully denied, appellate courts of the state have frequently said you need to ask for another one, another preempt, if you think you were wrongfully denied the challenge for cause. And I guess it seems to me that this is something of an analog. And why would we not require a request for the additional jurors at this point, additional preempts at this point?
Because the harm has already been done earlier on in the jury selection process by the court setting the parameters at 6.
So the strategy is set for 6.
The strategy is set from the very beginning. Also, when a cause challenge is denied, that's something that happens later on during the process frequently. Not always. It varies from judge to judge in how they conduct jury selection in their courtrooms. But a denial of a cause challenge, if the lawyer wants to assert that cause challenge was erroneously denied in order to preserve the issue of the denial of the cause challenge, he's got to say, Judge, not only were you wrong, but I need another peremptory to cure your error. That's not what happened here.
Let me ask you, if I could, to shift gears for a minute so you don't run out of time.
Yes, sir.
Let's talk a little bit about the jury instruction question.
Yes, sir.
Help me understand what you think the rights are of a licensed bail bondsman to use force to take a client into custody. How that might differ from the rights of a police officer to effect an arrest, and whether you think that affecting the taking into custody, because as I understand the scenario here, he was trying to put the grab on him to go surrender, and you never really had him securely in custody. Is that technically an escape under the use of force to prevent an escape statute?
I think so, and here's why. Mr. Brinson, the bailee in this case, had failed to appear for court. He had failed to appear for court, and so Mr. Buchanan was out to apprehend him. He indeed was a fugitive. So Mr. Buchanan...
I'm not debating the fact that he had a right to arrest him.
Yes,
My
sir.
question is, in effecting that arrest, what right do you think either springs from the contractual relationship between the parties, from common law or from statutory law, for the bail bondsman to use force And how would you compare the bail bondsman's right to use force to make an arrest vis-a-vis a police officer who might just arrest somebody else for something?
Well, I think that is described in Section 776.07, which provides that a law enforcement officer or other person with an arrested person in his custody has the authority to use any force he reasonably believes necessary to prevent the escape of that person. As a matter of common law, under Register in the Florida Supreme Court and Taylor from 150 years ago in the U.S. Supreme Court, the bailee is deemed to be continuously in the custody of the bondsman. Therefore, any breach by the bailee constitutes the functional equivalent of an escape.
One of the things that I never looked at in this case, and I suppose I ought to in the record, is what the actual terms of the bond contract are. Does the bond contract here speak to any of the issues that we're concerned with, as far as the right of custody and the right of the bondsman to grab him, that sort of thing?
Well, I don't know that it does, and to tell you the truth, I'm not sure that the bond contract is part of the record on appeal in this case.
The reason I ask that is in doing some of my own research on this, and I think we all recognize that the rights of a bail bondsman in Florida aren't particularly well defined in the case law, certainly not in the statute or the case law. You know, I ran across an AMJUR section that talks about that the rights of a surety to arrest or capture arises from the private rights established by the bail contract between the principal and the surety. And so that got me to thinking that, well, you know, if that's true, it would be nice to see what the bail contract says.
Well, the standard contracts, and there's no reason to believe that this was anything other than a standard contract, is you have the following obligations, and I can do the following if you fail to appear for court.
There's also a standard real estate contract that they get modified all the time.
I understand.
I understand the reality of the criminal justice world. Usually, you know, there's not a lot of negotiation in the bond contract, but I don't think is there a statutory form for a bond contract? I mean, I've signed a million streeters over the years, but I'm not sure that I've ever actually sat down to read it in detail.
I don't believe it's a statutory form.
So insurance company A might have a different form than insurance company B and C, and they might allow for different rights and liabilities.
Well, just by, you know, anecdotally, the bond contracts that I've seen over the years myself, without necessarily having studied them in the gravest detail, are fairly standard in the basic terms, and there may be some differences, but they're generally standard insurance contracts.
Right. I guess my only question there is if the AMJUR citation is correct, that essentially the right to take him into custody is essentially a matter of contract between the principal and the surety. And to support the requested instruction, did you have an obligation to demonstrate to the court that you had that contractual obligation, had that contractual right?
Well, and it may be that was not ever fleshed out at trial because it was never in dispute that this was the bondsman and he had a right to apprehend this fugitive bailee. So the issues were, that aspect of the issues weren't disputed.
Well, and the one thing that perhaps is clear under the law, under 90322, is that a bail bondsman has a right to arrest his bailee if there's a breach of the bond. I guess,
yes.
And I guess here there was really no argument by the state that there wasn't a breach of the bond.
Absolutely none. No, that was agreed. There was no dispute about that aspect of it.
Okay, I have a question for you about the jury instruction. You've made reference to 776.07.
Yes, sir.
And it's your position, I guess, that the bail bondsman is another person who has an arrested person in his or her custody.
Yes.
And the standard then becomes any force reasonably believed to be necessary to prevent the escape of the arrest person.
Yes.
But that's not the proposed jury instruction you asked for that was denied, right? The
Well,
proposed jury instruction talked about any force that he reasonably be necessary to defend himself or another from bodily harm while making surrender, which is a whole different section. So we can argue about whether 05 applies or not, but if you're arguing 07 applied, isn't it true that you didn't ask for a jury instruction that tracked the language of 07?
Well, the key issue that what the state has argued is that the defect in the proposed instruction was that it provided that a bailed bondsman need not attempt to withdraw, need not retrieve.
Okay, but now you're arguing you have certain rights under 07.
Yes, sir.
But you never asked for a jury instruction to instruct the jury on those rights under 07, did you?
I think the proposed jury instruction substantially alerted the trial court that this is the issue that's being tried here, and we're entitled to the jury being instructed that this individual defendant, as a bailed bondsman, is in a somewhat different situation than your ordinary citizen who just happens to be.
And therefore can do what? Can he use reasonable force to prevent escape? Because you never asked the jury to decide whether he used reasonable force to prevent escape, right?
He can't. Well, first of all, there is the issue of escape. But second of all, under the facts as they were tried, the testimony of Mr. Buchanan was that what actually ended up causing him to decide that force was necessary was that the individual, Brinson, started reaching under his seat as if...
Why doesn't the standard self-defense instruction, use of deadly force, address that problem?
Because it doesn't address the unique situation of a bondsman taking a bailee into custody. And that's the difficulty.
You have run over your time. I'm going to go ahead and give you an extra 3 minutes for rebuttal and add it to the state's time.
Thank you very much, Your Honor.
May it please the Court. My name is Rebecca McWigan, and I represent the state in this matter. The state agrees with the Court. The peremptory challenge issue was not preserved for appeal. In order to preserve it for appeal, they needed to object before the jury was sworn. They did not do so here.
Why did they need to do that?
Why didn't they do that?
Why did they need to do that? I mean, it seems to me that once the trial judge rules, why would they be, there's no real question but that the issue was raised for the trial judge, and he had an opportunity to either get it right or get it wrong.
Well, under the facts of these circumstances, the trial court believed that they had come to an agreement whereby they were waiving the 4 extra peremptory challenges based on his assertion that he would not sentence him to a life sentence.
I didn't see that in the record.
That's in the record. It's in the motion for new trial area. The transcript says that he doesn't have a transcript of it at the motion for new trial, but we did discuss the 10 challenges, and I think the agreement was, and I stated at that point, if he was convicted, that I would sentence him to the minimum of 25 years, and based on that, everyone agreed 6 challenges per side was the appropriate number of challenges.
Didn't the record, now that we have the record, doesn't the record belie that the judge's understanding of what actually transpired at jury selection wasn't quite accurate?
No, I don't think that it does. I think that the record shows that they agreed to it, and the reason why is because...
Maybe we can make it easier. Can you just point to me in the record of the jury selection where, not what the judge recalls months later at the motion for new trial, but show me the part where the judge's memory springs where everybody says, we're good to go with 6.
They didn't affirmatively state it on the record, I don't believe. But that's why they needed to re-object before the jury was sworn and remind the court that they still had an outstanding objection.
Did you make that argument in your brief? Because I don't recall seeing any preservation argument in the brief.
I did not, but this court should always consider preservation.
Well, let's talk about the issue that you actually raised in your brief. Is it your position on the peremptory challenges that it was not error, or that it was harmless error, or both?
My position is that, well, it's both. It's not error for the trial court to have done this.
So whenever the court and or the state agree to limit a punishment to something less than the statute calls for, it can change the number of preemptors.
If the defendant...
If in a felony case, the judge says, I'm not going to give you more than a year, then all of a sudden you can only give the peremptories for a misdemeanor because the judge has said he's not going to give more than a year?
No.
Why not? Because it's not more than a year then.
Well, if the parties agree to it, they can waive any of these rights.
Well, I don't disagree with that. And what I'm trying to focus on is show me where the parties agree. Because I think the discussion ends if you can show me definitively. We all agree that the statute says 10 if it's punishable by life. And we all agree that this is punishable by life. And we all agree that the parties could agree to the contrary. All I'm saying is, show me where in the record the parties agree to the contrary. I buy everything you say, and all I'm now asking you is, show me.
I can't say. The defense counsel never definitively stated on the record that they agreed to it.
Well, don't you think that where the defendant has that right, that both the trial court and the state have some obligation to make certain that the record's clear on that point?
Well, the defendant also has an obligation to re-object and remind the trial court of their objection. They never asked for any more peremptory challenges. They didn't indicate that they had any dissatisfaction with the jury later. And so, therefore, it's not preserved, and they waived it by not preserving it.
Don't you waive the preservation issue by not asserting it in your brief?
No, because this court is always supposed to review for preservation whether the parties raise it or not.
Tell me a little bit about the jury instruction issue, because I find that to be particularly interesting. Do you agree that the statute gives the bail bondsman the right to arrest
Yes.
errant bailee?
Yes.
And do you think implicit in that is the right to use reasonable force?
Reasonable force, yes. Deadly force, no.
Well, I mean, deadly force might be reasonable. I mean, I guess that's my question. Are you saying that as a matter of law, deadly force, a bail bondsman could never use deadly force to effect an arrest or to prevent an escape?
No, that's not what we're saying. We're saying that the bail bondsman doesn't have any more right to use deadly force than the average citizen under the Florida statutes, which would be in the defense of himself or others.
Well, but an average citizen doesn't have a right to go out and arrest someone. Isn't the rights of a bail bondsman vis-a-vis his bailee more akin to the rights of a police officer than his right to... I mean, normally, a citizen can't just walk up to you on the street, grab you, slap cuffs on you, and drag you down to the county jail. But a bail bondsman can, assuming that...
Because they have a contractual right to do so.
Exactly.
And they're also given those rights by the power of statute. But when the legislature set up the chapter on justifiable use of force, they only carved out an exception for law enforcement officers to use deadly force in effectuating arrest. And in those instances, even, they have to follow a certain set of guidelines before they can use deadly force. The United States Supreme Court has specifically found that use of deadly force against an unarmed, non-dangerous person is unreasonable. So,
Well, and what I guess it depends on the context. I mean, I guess in retrospect it's unreasonable, but we see shootings all the time where the police officer's defense is, I saw him reaching into his belt buckle and it turned out to be his lighter, and I shot him. And, juries clear police officers all the time because it wasn't unreasonable. It may have been erroneous, but not unreasonable.
and that was sufficiently covered by the standard instruction that said if you reasonably believe that he was subject to deadly force, that he responds in kind. The reason why we don't let bail bondsmen use deadly force the same way we do police officers is because police officers are effecting a seizure for the purposes of bringing them to jail and justice, and as they commit crimes, they've not necessarily been in jail and let out. The bondsman is arresting them because they're trying to recover their money. This $7,500 bond that he was going to lose, and he shot him because he was going to lose that money if he couldn't catch him. We don't want our bondsmen running around shooting people over money.
Do you think a bail bondsman, I think you and I agree he has a right to make an arrest.
Yes.
And do you think in the process of that, I think we agree that he has a right to use reasonable force?
Correct.
So that if he says, okay, John, you need to come with me, and Johnny says, I'm not going, he's allowed to put the grab on him or attempt to put the grab on him and put the cuffs on him.
Right.
And so how does that differ then from the law enforcement officer's right to use force, where it says that he need not retreat or desist from efforts to make a lawful arrest because of resistance? I mean, so far one is codified and one seems to be common law, but so far I'm not really hearing a substantive difference.
Well, their argument was that he's entitled to use force under 776.051, not 776.05, and one's to prevent the escape and the other one's to make the arrest. But
Well, let me ask you this about the proposed jury instruction that the trial court denied. Is it your position that that proposed jury instruction was inaccurate or simply unnecessary because it's covered by general instruction?
it's inaccurate. It's an accurate statement of the law, and that's why the trial court...
Sorry, it's inaccurate?
Inaccurate.
Okay, what part of it is inaccurate? I'm looking at it now. The first thing it says is a bail bondsman need not retreat from or stop efforts to make surrender of a bailee because of a resistance or threatened resistance to the surrender or detention. Do you dispute that, or is that an accurate statement?
That's an accurate statement.
Okay, the next sentence says the bail bondsman is justified in the use of any force that he reasonably believes necessary to defend himself or another from bodily harm while making surrender. Is that an accurate or an inaccurate statement?
That's accurate.
That's accurate?
If he's...
You said that was accurate?
Yeah.
Okay, and then the third sentence is that force is justifiable when necessary in surrendering a bailee on his bond. Is that an accurate statement?
I think that's where you get into the inaccurate statement of the law, and it goes on, and that's where it starts becoming inaccurate, because then it starts talking about how they can fire in the direction of a vehicle that the person's traveling. It doesn't talk about placing third parties in risk. It doesn't require that the law enforcement officers are required to give notice if they can, and the fleeing person has to pose a threat of death or serious physical harm to the officer or other, or they have to reasonably believe they've committed a crime involving the infliction or threatened infliction of serious physical harm to another person to use deadly force.
So the problem is the instruction is not complete enough? Because it looked to me like the three sentences were pretty accurate. And you're saying there needed to be greater modification of it in order to limit it? Is that the argument is?
Yes.
Was there more to the proposed instruction than the three sentences that Judge Palmer just read to you?
There's more than that, and that's what I was going on. The use of force is not justified, but it's unlawful, and that's accurate. But then they go on to the deadly force section, which is where they explain how they can fire at a moving vehicle or fire in the direction of the person without intent to kill. There are cases from other jurisdictions that talk about placing third parties at risk is objectively unreasonable for the bondsman to do so.
Does Florida Statute 776.07, which is the use of force to prevent escape, apply to bail bondsmen when it says a law enforcement officer or other person who has an arrested person in his or her custody? If a bail bondsman takes a client, picks him up to take him to jail, does he qualify as a person who has an arrested person in his or her custody?
Once he's arrested them, I believe that he may qualify under that statute, but he hadn't arrested him at this point.
Okay, but once he brings him into his custody, then you agree that 07 applies?
The case law seems to indicate that this only applies to law enforcement officers or those summoned by them, and under that circumstance, no, he would not qualify under that statute is he's not summoned by law enforcement officers.
No, the one about summoned by an officer is 05. I'm looking at those, there's two separate standards
I
here.
understand that there's...
05 is a law enforcement officer or a person whom the officer has summoned or directed to assist him. It's your position that a bail bondsman doesn't meet that definition, correct? 07 is a law enforcement officer or other person who has an arrested person in his or her custody. Would that apply to a bail bondsman once he had taken a client into custody?
Yes.
Okay.
Let me ask you, though, you seem to distinguish here by the fact that Brinson wasn't yet in custody. Is that accurate?
Yes.
The parties, or at least the appellant here, cites a 1954 Supreme Court case, Register versus Barton. It says one under bail is in vicarious custody of his bondsman, whose dominion is a continuance of the original imprisonment, and the principal may be apprehended by his bondsman even under extreme circumstances. So I read that case, and it seems to imply to me that in essence, when the bondsman posts the bond, the prisoner essentially goes into the bondsman's custody, and that the rights of the parties are thereafter contractual. And I'm not suggesting without limit. I'm not suggesting you could put in paragraph 12, if you don't call me at noon every day, I have a right to come over and execute you or something. But, you know, within reason, you know, that case, that 1954 case, seems to suggest that once you get out of the slammer, you are in the constructive custody of the bail bondsman, subject to the terms of the contract between the parties. So if that's accurate, then for the purpose of the escape statute that Judge Palmer was reading to you, wouldn't you then, if I'm trying to apprehend you, I'm your bail bondsman, I'm trying to apprehend you, and you're running away from me, aren't you escaping under that statute because you're in my lawful custody, even though you're not in my physical custody?
No, I think that has been abrogated by the statutes that says that they have to arrest them, but to put them in their custody in order to surrender them under their bond. That's 903-22 and 903-29. They may arrest the principal for the purposes of surrendering the principal to the official in whose custody he or she was at the time bail was taken, or who custody the principal would have been placed if she'd been committed. I think they have to arrest them first. He needed to identify himself in some way and say, you're under arrest, you're coming with me, you violated your bond.
So the bondsman has to jump out and say, kind of like that show on television, what is it, Big Dog or something?
I don't watch that.
I mean, actually, don't you think these guys, you know, don't you think in Palatka, everybody knows who the local bail bondsman is? And if they bonded you out, I mean, come on. Come on,
I know that Palatka is a small town. Kevin Brinson,
even here in Daytona Beach,
that he changed his face, he looked different, and that he didn't recognize him. So, yes, I think you do need to identify yourself. If he had a shirt on that said bail bondsman on it, that probably would have been sufficient.
So if I buy one of those shirts that says FBI, I can just take people in?
No.
Okay, thank you.
If you have no further questions, then we would ask that you affirm.
Thank you for your argument.
To respond briefly, I think that the questions are correct, that the custody is continuous once a person is admitted to bail under the care of a surety, under the bondsman.
Is a bail bondsman covered by 776.05 or only by 07? Is he a person whom the officer has summoned or directed to assist him?
Well, there's really no law that answers that question conclusively. But
that's why I'm asking you the question, so maybe there would be.
But there should be, because the entire function of a bail bondsman is to provide security and law enforcement related security to ensure that the individual is going to come to court. The other principal way that courts, through the assistance of law enforcement, make sure somebody's going to come to court is to keep them in jail, where the jailer then brings them to court whenever it's necessary. So I think both of those statutes apply.
Well, it would appear that 07 both is more likely to apply and actually gives the bail bondsman more right to use force, right? Because 05 is to prevent bodily harm and 07 is to prevent escape.
Yeah, I agree with you completely. And that's why we have focused on 07, because what you have here is an individual who's already a fugitive who's trying to run away more while he's in the presence of the bondsman who's trying to recapture him.
So when precisely may a bail bondsman use deadly force?
As 776.07 provides, and I'm paraphrasing here, when he reasonably believes that force is necessary to prevent escape. And so you have...
So self-defense or defense of others would not come into this at all?
Not necessarily. It can under a given fact pattern, but not necessarily.
So if a guy's on bond for shoplifting and he doesn't want to surrender and he's running down Main Street there in Palatka, the bail bondsman can just start blasting away.
That's why the law uses the term reasonableness.
Well, if it's reasonable, let's say that the bail bondsman's not very fast, and so, the only way he's going to catch up to him is with his 45.
But if you're running down Main Street and there are other members of the public walking down the street, it's not going to be generally determined to be reasonable.
That's a jury question.
And your jury instruction, this is where I do have a problem with your jury instruction, which seems a little bit over the top. Because we got the state to pretty much concede the first three lines, but then you go on to propose deadly force is not limited to firing in the direction of the person detained, so running down Main Street, blasting away, or firing at a vehicle in which the person's detained. So I guess my question is, doesn't that instruction go way over the top in allowing, you guys running down the steps of the courthouse there in Palatka, and, people are milling about the big tree, and the bail bondsman starts blasting away. Under your instruction, you're good to go.
I think that's a misunderstanding of what that portion of the proposed instruction is. That portion simply is definitional. It says, here's some examples of what deadly force means. That's all that instruction.
Well, but the main part of the instruction says it's okay to use deadly force if it's reasonable. And deadly force means blasting away at a moving car or blasting away at a running away fugitive. I guess it just seems to me that goes a little bit over the top.
Well, perhaps there could have been additional examples, but no one would disagree that those are examples of deadly force. So that's why I'm saying that those portions of the proposed instruction were merely offering definitional examples of what can constitute deadly force. That's one of the reasons that the proposed instruction says includes but not limited to.
Would a police officer have a right to, if an individual is arrested for shoplifting and he's in custody, sitting in the back seat of the police car, and somehow he opens the door and runs away, and the police officer can't catch him on foot, can the police officer just shoot him?
That's really controlled as a matter of constitutional law by the U.S. Supreme Court case of Tennessee versus Garner, which generally limits.
You and I agree that under that law, the officer could not shoot.
Correct.
So let's take the same scenario, but now the bail bondsman puts the grab on the fellow who's out on bond for shoplifting, and he's in the backseat of the bail bondsman's car, manages to slip away, and he's running down the street. Can the bail bondsman shoot him under your theory?
Well, that is, again, part of the function of the use of the term reasonableness. which, again, is something that can be argued to a jury based on specific nuances of fact in a given case.
So reasonable force by the bail bondsman, at least theoretically, could be more force than the police officer could constitutionally use, is your argument?
Well, first of all, a bail bondsman is not necessarily, for constitutional purposes, a state actor. I don't think either side has fleshed that out in this appeal. A bail bondsman is generally a private person, other than the bail bondsman has certain...
But your theory is there are circumstances in which the reasonable amount of force that could be used by a bail bondsman is more than the amount of force that a law enforcement officer could use in a comparable situation.
I'm sorry, I think I misunderstood your question initially. What 776.07 provides is that a law enforcement officer or other person...
Answer my question, if you will. Are there theoretical circumstances based on your theory where a law enforcement officer couldn't use a certain amount of force, but a bail bondsman could?
I don't think so.
Okay, so the bail bondsman is at least limited by whatever limitation is put on the law enforcement officer by the Constitution in a comparable situation.
Well, not necessarily, because a bail bondsman may be subject to a tort claim, certain tort theories that the bondsman wouldn't be subject to a civil rights action under 42 U.S.C. Section 1983. That would be the difference. But in terms of the actual application of force, where the bondsman is a criminal defendant for the use of that force, I think statutorily the standards are the same.
Okay, thank you, counsel.
Thank you very much, Your Honor.
Thank you, Booth.
Next case